If you have questions involving the policies and procedures described in this training, contact your Human Resources Department. Although we've long understood that sexual harassment is unlawful in the workplace, it's clear from news headlines that it's still prevalent. That's why it's critical that employees understand the law regarding sexual harassment and know their role and obligations. Sexual harassment can have lasting effects for individuals, organizations, and the community, including psychological trauma and stress-induced symptoms for the victim, a hostile work environment for employees, damaged reputations, negative publicity, civil liability, and even criminal charges. This is why workplaces can't take sexual harassment lightly.
Sexual harassment, and under Title IX, sex-based harassment, has been recognized in legislation and court rulings as a form of discrimination and is, therefore, illegal. Your employer is required by law to have a policy that forbids sexual harassment. The U.S. Supreme Court and lower court rulings require employers to prohibit sexual harassment and take aggressive measures to investigate, document, and correct it when it occurs. An employer may be liable if it has or should have knowledge of sexual harassment, or if, under Title IX, it has knowledge of conduct that reasonably may constitute sex discrimination.
Employers that don't have or enforce a strong policy prohibiting sexual harassment can be sued, and public institutions can lose state and/or federal funding. This course is designed to provide employees with a basic understanding of sexual harassment and strategies to maintain a harassment-free environment in the workplace. We will define sexual harassment and discuss employees' responsibilities when it comes to sexual harassment and how to file a complaint. At the end of the course, you'll have a chance to test what you've learned with a quiz. So if you're ready, let's begin. Individuals of any gender can be the target of sexual harassment. In fact, sexual harassment may involve harassment of a person of the same gender as the harasser, regardless of either person's sexual orientation or gender identity.
That's because sexual harassment is a form of sex discrimination based on sex or gender, including pregnancy, childbirth, or related conditions, sex stereotypes, sex characteristics, gender identity, gender expression, or sexual orientation.
Although it doesn't have to be motivated by sexual desire, unlawful sexual harassment often includes unwanted or unwelcome behavior that's sexual in nature. This includes unwelcome sexual advances, requests for sexual favors, and other verbal, visual, or physical conduct of a sexual nature. Sexual harassment usually takes two forms:
quid pro quo and hostile work environment.
Quid pro quo is Latin for this for that. In other words, something is given or withheld in exchange for something else, like when submission to sexual misconduct is explicitly or implicitly made a condition of employment. Although it's less common than hostile environment harassment, quid pro quo is what most people think of when they hear sexual harassment. In quid pro quo harassment, a power imbalance exists between the two parties. One person has the power to grant or deny benefits to the other based on sexual behavior. A hostile work environment applies when unwanted sexual or gender-based behavior creates an intimidating, hostile, or offensive work environment, or unreasonably interferes with an employee's work performance. Common examples include content or images in the workplace, comments or jokes, and/or sending offensive emails or text messages. Although some might perceive the content as humorous, this behavior could be considered hostile. Hostile work environments can occur at all levels of an organization, involving administrators, supervisors, coworkers, and even contractors. An example of this might be a group of males routinely whistling and making suggestive comments about a female coworker to such an extent that she begins skipping work to avoid them. There are some similarities between quid pro quo and hostile environment harassment. Both forms of harassment are illegal. Employers must take action to stop, prevent, investigate, and remediate both types of harassment. In both types of sexual harassment, men can harass women or other men, and women can harass men or other women. The gender of the harasser and the victim make no difference. Sexual harassment is still illegal. Offensive behaviors that contribute to a hostile work environment can have devastating effects, not only on individuals in the workplace, but on the organization as a whole. Let's look at some behaviors that can be considered sexual harassment: verbal, nonverbal, and physical. Examples of verbal sexual harassment may include threats or bribes for unwanted sexual activity, sexual or derogatory comments and innuendos, sexual jokes or rumors, sexually suggestive sounds, offensive graffiti, spreading rumors, letters, notes, telephone calls, and other materials of a sexual nature, and offensive emails, text messages, videos, and social media posts. Examples of nonverbal sexual harassment may include ogling or leering, pointing or winking, stalking, sexually suggestive gestures, facial expressions, or bodily movement, and taking, showing, or distributing humiliating or degrading images of a sexual nature, including exploitative, suggestive, or altered digital photos or video clips. Physical sexual harassment may involve actions such as touching, groping, patting, pinching, stroking, squeezing, tickling, or brushing against someone, snapping someone's bra, pulling down someone's pants or shorts, or flipping up or reaching under a skirt, and attempting or committing a sexual assault, which is also a crime. A single severe incident can by itself constitute sexual harassment. For example, exposing one's genitals or physically fondling or groping a coworker is enough to create a hostile or abusive environment.
If, however, the conduct is less extreme, inappropriate jokes, for example, the courts look for a pattern of repeated, routine, or generalized harassment.
Your employer is required to include anti-harassment policies and procedures that reflect your state's law in its general policies. If you have questions about these policies, ask your supervisor or the designated manager in your Human Resources Department. Victims of sexual harassment in the workplace can file a lawsuit. Whether the employer can be held liable, though, depends on the specific details and which law is invoked. For example, an employee files a claim that their supervisor's harassing behavior has directly caused them to miss out on a promotion. If a claim of sex discrimination is brought under Title VII of the Civil Rights Act of 1964 or under state law, then the employer would be strictly liable for the discriminatory behavior.
Claims filed under Title IX, however, now require the employing educational institution to have knowledge of the harassing behavior. This means that the school and Title IX coordinator must respond promptly and effectively.
Supervisors and managers have a clear obligation to report incidents of sexual harassment, and they're required to take prompt remedial measures if sexual harassment occurs. But not all the responsibility lies with them. You're required to know and follow your organization's anti-harassment policy as well. It will be similar to this one. All employees have a responsibility for keeping our work environment free of unlawful harassment and discrimination. Any employee who becomes aware of possible harassment or discrimination is obligated to report the matter to the organization and assist in our efforts to take prompt and effective remedial action.
You should know your employer's policy on sex-based harassment, including sexual harassment, including how and where to report an incident. Report to the designated human resources official if you have been sexually harassed, if you know that another employee is being sexually harassed, or if you believe that another employee may have been sexually harassed. When reporting, use caution and consider the personal and professional impact this might have on the alleged victim.
Once you've reported a case of sexual harassment, an official should document details regarding the incident and promptly investigate the complaint according to the organization's policy. This offers the best chance for a safe resolution for everyone. Could an investigation find the employee falsely accused? Yes. Managers must take allegations seriously and investigate fairly. The employer is required to conduct a prompt and unbiased investigation to ensure that the rights of the accuser, the reporting party, and the responding party are respected. A manager who knowingly files a false report of sexual harassment may face disciplinary action and other consequences. In addition to reporting sexual harassment to your employer, you can also file a complaint with the EEOC, which enforces federal anti-discrimination laws. Charges must be filed within 180 or 300 days of the last incident of harassment. The EEOC will look at all incidents of harassment when investigating the charge, even if the earlier incidents happened more than 180 or 300 days earlier. No one wants to have their words or actions interpreted as sexual harassment. Let's examine some best practices that can help you avoid interactions that might lead to charges of harassment. A little common sense and courtesy will help ensure a comfortable workplace for everyone.
Read signs and clues. It's not unusual for coworkers to have personal relationships that extend beyond work. However, if your coworker makes it clear that they're not interested in a personal relationship, respect their boundaries and stop.
Always think twice before clicking send on electronic communications. This is particularly true of messages that aren't related to the business. Remember that personal emails, texts, voicemails, and social media posts are accessible forever, even if you think they are deleted. Be careful with your sense of humor and conversation. Stick to jokes and topics that would be appropriate to a reasonable person. Be aware of personal remarks about yourself or others. These can be a problem, especially if they refer to appearance or behavior. Keep your private life private and extend others the same courtesy. Consider personal space and boundaries. Remember that touches can be interpreted differently by different people. Some people don't like to be touched at all. Handshakes are usually considered a polite gesture, but more intimate acts may not be.